Hi, my name is John Lindsay. I'm a patent attorney. I wanted to make a couple of comments regarding confusion on the recently passed inventors legislation. I've already been getting a lot of questions on that, and there's already a lot of confusion out there. Now, admittedly, a lot of the terms within the legislation need to be clarified, and the courts and patent office will do so over the next several years. But one of the points that is starting to take hold that is incorrect, it regards the first to file aspects of the legislation. I'm getting questions from people believing that the first to file aspects of the legislation means the party that files first, no matter the scenario, automatically has lawful patent rights within the filings. And they interpret that to include the situation where Party A conceives of an invention, they're working on refining it, Party B comes along, sneaks in the office building of Party A, misappropriates the intellectual property, and files a patent application for that. People believe that because they were the first to file, that Party B somehow has gained some rights. That is not what the legislation contemplates. The legislation contemplates Party A creating a technology and Party B creating the same technology independently, neither party having any unlawful access to the other's intellectual property, and then one of those two parties makes the prior filing. That's the primary scenario that's contemplated by the legislation. And so that should clear out part of the confusion. Now, I should also add that the new legislation also directly contemplates the scenario where the confusion is occurring. That is, it provides what are called derivation proceedings, so that if, in the scenario I named earlier, Party A conceived and created an invention, they were refining it, Party B comes along and unlawfully accesses the information of Party A, heads to the patent office first and has a filing, well, there are derivation proceedings that are contemplated in that scenario. So just to summarize before we close out here, first to file does not automatically mean any party who was the first to file automatically has rights. Before this legislation was passed, a party who files a patent application, they have to be the party who conceived and reduced the technology to practice actually or constructively, and this recently passed legislation has not changed that. If you need help in your situation, feel free to contact me for some assistance. Take care. Thank you.